Hello, everyone, and welcome to today's webinar. My name is Debbie Brenneman. I'm a partner in Thompson Hine's labor and employment practice, working out of our Dayton and Cincinnati offices. And I am delighted to be joined today by one of my labor and employment colleagues from the Cleveland office, Brittany Mallow. Before we begin, just a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees, including the PowerPoint, within 48 hours of today's presentation. If you have questions during the webinar, please feel free to use the question box that's located in the control panel on the upper right side of your screen. We'll answer as many of those as we can at the end of the webinar if we have time. But thank you for your interest, and let's begin our discussion today. First of all, I'll outline, Brittany, if we can go to the agenda. There we are. What will we be talking about today? We will give some insights into the final rule of the FTC and what the requirements are under that rule. We'll talk about permissible restrictive covenants that survive the final rule. There's certainly a number of legal challenges going on that have some important implications. We'll be talking about those and where they stand. And we will also be talking about strategies for both complying with the rule, preparing those notices, and looking at your active agreements.
All right, thanks, Debbie. So yeah, kind of letting you know the schedule here of kind of how this has progressed. For the FTC's final rule, it was first proposed, it was first announced January 5th of 2023, and then the vote on the proposed rule was delayed significantly, and we didn't actually get the final rule issued until April 23rd of 2024. Oh, one second, slides are going crazy here. And the FTC kind of gave some insight in what the guidance that came out along with the final rule as to its motivation for the final rule itself, where they articulated that it's really concerned with harm that non-competes purportedly inflict on workers whose compensation and mobility are stymied by non-competes, and new businesses that find it difficult to break into an industry in which skilled labor is locked into existing employment agreements. So those were two of the main focuses in the, I guess, the FTC's guidance that came out with the final rule as to why it felt so compelled to issue that. So what's covered by the final rule? So the rule defines a non-compete clause as a term or condition of employment that prohibits a worker from, penalizes a worker for, or functions to prevent a worker from seeking or accepting work in the United States with a different person, where such work would begin after the conclusion of the employment, or operating a business in the United States after the conclusion of employment that includes the term or condition. So it's important to note here that this doesn't cover competition where the employee would be competing while still employed with the employer, whether that's with a different company or it's they're operating their own business in competition. This is really focused on post-employment competition. So the broad definition does cover agreements with any workers, including employees, independent contractors, externs, interns, volunteers, etc. The rule also applies to any person or employer, including natural persons, partnerships, corporations, associations, any legal entity within the FTC's jurisdiction. And this includes any person acting under the color of authority of state law.
So basically everyone. There is a narrow exception to the final rule, and when I say narrow, I mean very narrow. It's called the senior executive exception. So non-competes that exist prior to the effective date of September 4th with senior executives as defined by the rule may remain in effect. So importantly, if companies are onboarding key executives between now and September 4th, regardless of what happens in the court that we'll talk about in a few minutes, you still want to have these agreements even though the rule is looming, because ones that are entered into prior to September 4th can stay in effect, but after September 4th, you cannot enter into those agreements even with senior executives. So who is a senior executive? You know, my clients and I have spent a lot of time kind of parsing through this in the last couple of weeks as this rule gets closer and the legal landscape is a bit uncertain. First, there's a compensation requirement. So senior executive is defined as a worker in a policy-making position with a total annual compensation of at least $151,164. Drives me crazy that the government can never just give us round numbers, but that's the number that they gave us. So taking a look at the rule, what is total annual compensation? Well, under the rule, that includes, it's not just base salary, that does include other, traditional bonuses or compensation that senior exec receives, like performance-based bonuses, something pursuant to a prior contract or promise. And it also allows for the entire amount of the bonus to be credited to the total annual compensation, kind of increasing the likelihood of triggering those folks who would fall into the rule. So deciding, does the person meet the compensation threshold is pretty easy. What's a little bit more difficult is the second component, which is that the senior executive has to be in a policy-making position. So according to the rule, that includes a business entity's president, CEO, or the equivalent of that, or any other officer of an entity who has policy-making authority. So anybody in the organization that has meets the salary threshold and has policy-making authority. But that again becomes a little bit complicated. Now, first, the definition states that if an officer of a subsidiary or an affiliate that's part of a common enterprise, if one of those individuals has policy-making authority for the common enterprise, they can be deemed to have policy-making, be in a policy-making position such that the exception would apply. But the flip side is not true. So if you've got somebody who is in a policy-making position over a subsidiary, but not over the common enterprise, then that would not meet the definition and the exception would not be triggered. Policy-making authority is further defined in the rule as final authority to make these policy decisions that control significant aspects of a business entity or the common enterprise. So that means it's not good enough if the person has some advisory role or they influence the decision. They have to have final authority to make those policy decisions, and it has to be for something that affects a significant aspect of the business. So that's a lot of the debate that's going on. What does that mean, significant aspects of the business? And it really is getting into, really a case-by-case analysis there. It's something, it's part of the landscape that's going to continue to have to be fleshed out a little bit. There also is an exception with regard to the sale of a business. This was something that was a little bit in flux in the initial proposed rule. There was a certain percentage that was tied to it, and the FTC had floated allowing an exception if the ownership interest was as low as 10% or maybe up to 50%. But when the final rule came down, the exception applies only if it involves the disposition of the person's complete ownership in the interest in the business, or all or substantially all of a business entity's operating assets. So if the individual is not divested of their entire interest, then the exception would not kick in. There's also an exception in the rule called a good faith exception, and it says that it is not an unfair method of competition and not a violation of the rule to enforce or attempt to enforce a non-compete clause or to make representations about the enforceability of a non-compete if there's a good faith basis to believe that the non-compete ban does not apply. That might come into place, I suppose, in an evaluation of whether someone is a senior executive, but the commentary associated with the rule said that active litigation would not be sufficient to trigger this good faith exception, sort of anticipating that there would immediately be lawsuits about it, which of course there were. Now, what about events that happen before the effective date? Well, the ban does not apply where cause of action related to a non-compete accrues prior to September 4th, the effective date, and current litigation that's going on is still lawful as well. I just had a conversation with a client an hour or so ago about an executive who was leaving, And if they leave before September 4th, then we can file an action and seek to prevent them from taking the new position, and that that ruling could stay in effect. But if again, so if anybody leaves between now and September 4th, regardless of what happens with the litigation, those actions are still permissible. There had also been a lot of question among practitioners about what would happen with regard to forfeiture for competition clauses that are contained in deferred compensation agreements. If we could go to the next slide, Brittany. Those are also banned under the rule except for senior executives. So if there are forfeiture for competition clauses in deferred compensation contracts for senior executives that meet the definition and that are in place before September 4th, those can stay. Other than that, the final rule says that those forfeiture for competition clauses will not be enforceable either.
All right, thanks, Debbie. So as Debbie's mentioned several times now, the final rule is going to take effect September 4th, 2024, unless there is an injunction stopping it from doing so. And what's important about that is if summer's gotten away from you, like it has for me at least, that is the week following Labor Day. So important to note, as we'll talk about notices and things like that that need to be put in place, we really need to be thinking about that this week, next week, leading up to Labor Day, because if the final rule were to go into effect, all those mechanisms to issue notices and everything are going to have to be primed and ready to go in order to make sure that that happens by the effective date to be in compliance with the final rule. So challenges to the final rule. Is it a done deal? Is it going to go forward? Multiple groups have filed litigation to attempt to block the rule, but as of now, there is no nationwide injunction to stop the final rule from going into effect, and there is nothing guaranteeing at all that there will be. So as of right now, it looks like it will go into effect on September 4th. To kind of walk you through the different cases that are going on. So the first suit was filed the same day the final rule was issued in the Northern District of Texas by a global tax preparation service, Ryan LLC. The U.S. Chamber of Commerce, Business Roundtable, Texas Association of Business, and Longview Chamber of Commerce came together and filed suit in the Eastern District of Texas the following day. In both of those cases, they were seeking the nationwide injunction and a stay on the effective date. Then after that, a small business, ATS Tree Services, filed suit in the Eastern District of Pennsylvania on April 25th. And most recently, Properties of the Villages, Inc. filed suit on July 2nd in the Middle District of Florida. So kind of getting into the specific legal arguments, there are essentially the same legal arguments across the four lawsuits. The FTC lacks the authority to issue the rule in the context. It's a sweeping abuse of the authority under Section 5 of the FTC Act. The final rule is impermissibly retroactive. It violates the Administrative Procedures Act, not rationally connected to economic data. There is some data out there that suggests the opposite of what the FTC says. So depending where you get your data from and how you're looking at it, that's how these different business groups are coming in stark contrast with what the FTC has proposed. Another argument here is it's arbitrarily chosen without duly considering alternatives. And even if it is statutorily authorized, the rule rests on unconstitutional delegation of authority to the agency. So again, these are arguments that exist, and you will see kind of throughout all four of the different cases that have been filed. Some updates on each of the cases. So under the first to file rule, the court in the U.S. Chamber of Commerce case, which was filed second, issued a stay on the proceedings because Ryan LLC had filed first. So instead of sitting and waiting that out, they decided to join as plaintiff interveners, which the court granted. So now the U.S. Chamber of Commerce and the other related business entities have now joined as plaintiff interveners in the Ryan LLC case, and the Chamber of Commerce case has been dismissed. So we were all anxiously awaiting the ruling from the Ryan LLC case in Texas that came out on July 3rd. And this is when it was expected that there would be a nationwide injunction. To much of the surprise of a lot of us who've been watching this stuff closely, there was a preliminary injunction issued by Judge Ada Brown in the Northern District. However, it was very clear that the injunction only applied to those plaintiffs and plaintiff interveners in the case. The court specifically declined to extend that injunctive relief even to members of the Chamber of Commerce and the Business Roundtable and those other business organizations, because they said that the members had not demonstrated the necessary associational standing, and this was not addressed in the briefing. So it was a very strong decision, which indicates that it's very likely that the final ruling that's expected by August 30th will extend that injunction beyond just this preliminary phase. However, the court did subsequently deny the plaintiff intervener's motion to reconsider the scope of the preliminary relief. So the motion was filed by the plaintiff intervener saying, hey, court, can you take a look at this again and extend it to at least the members here? And the court declined to do so. So it's up in the air of whether or not, first of all, if the court will actually grant in its final ruling extended injunctive relief, and also if it will also further go to the members of these organizations, or if it will kind of mimic the original ruling, which will only apply to the plaintiffs and the plaintiff interveners in the case. So a very narrow ruling. So we'll be watching closely this case, and we expect, it says by August 30th. Every time it's said by a date, thus far the decision has come out on the date, so I'd expect to get that on August 30th. All right, so the ATS Tree Services case, this one's in Pennsylvania. On July 23rd, in the ATS Tree Service case, the court actually declined to block the final rule and found that the FTC did have the authority to issue its final ruling and did not find it likely that ATS would be successful on the merits of the case. So they did not issue any type of injunctive relief there. And this actually, I mean, this wasn't surprising to us that have watched as well. We have Judge Ada Brown in Texas, a more conservative judge. We have the judge in Eastern District. We kind of were expecting this decision, so we knew we would have at least these two kind of conflicting opinions out there. But then on July 2nd, another suit popped up in the Middle District of Florida. Interestingly, in this case, the plaintiff only filed for injunctive relief as to them. There is a hearing today, which we'll be looking to see when that decision comes out, whether or not stay and preliminary injunction will be granted. However, the court could extend it beyond what plaintiff asked for and give us a nationwide injunction here. That would be a long shot. I wouldn't expect that to happen, but certainly something we'll be watching and monitoring throughout the day. So what could happen prior to September 4th's effective date? So there's a couple different options. I kind of touched on them, but just to summarize a little bit. So the Ryan LLC court could grant a national injunction, or they could vacate the final rule on August 30th. So we have to really kind of wait and see on that one. Or they could, like I said, they could follow what they did with the preliminary injunction reasoning, grant the injunction, but only limit it to the plaintiff and plaintiff interveners again, meaning that unless you work for the Chamber of Commerce or Ryan LLC or the other associated plaintiff intervener business entities, you would not be covered by the final rule, or by the injunctive relief, sorry. A couple other options, so it's very unlikely, but the Ryan court could completely reverse course here and dissolve the preliminary injunction and go along with the ATS Tree Service case in Pennsylvania and say that the final rule can go through. Another option is in the Middle District of Florida. Like I mentioned, again, they could today go beyond what the plaintiff is seeking in that case and issue a nationwide injunction. I think that would be highly unlikely, but again, another possibility we could see.
Yeah, and just diving further into, I think we look particularly at the Ryan Court in Texas, what the possible paths are to a nationwide ban that court might issue. The first, as Brittany said, would be based upon the request for injunctive relief if there's a finding of a broader interest. And I will say that in the initial briefs, the court spent some time really recognizing and spelling out that it believes it would have authority to issue a nationwide injunction, and that the courts have done so in other circumstances, but found that the plaintiffs, interveners, had not set forth a case that there was a broader interest. And even on that motion for reconsideration, that was looking, back toward the original briefing. There have been some other there's been some other briefing. There's been some amicus briefs filed by other business organizations, and certainly heavy pressure from the business community to push for a nationwide ban based upon that injunctive relief. And at least one of those amicus briefs have also discussed the doctrine of vacatur, which is not really not injunctive relief, but a principle under which if a court finds that a federal rule, a rule issued by an agency, is invalid, then that invalidates the rule for everybody. It's not based upon a request for an injunctive relief, just that the rule, if it's deemed to be invalid, is invalid. End of story. So that argument has been positioned by, again, by at least one of those amicus briefs. We'll see if the court is persuaded by that or anything that suggests that there is a broader interest. So those are the ways that especially the Ryan Court could go. Certainly under those challenges, there will be a lot of uncertainty that remains. So presuming that the Ryan Court out in Texas and the ATS Tree Services Court in Pennsylvania maintain their preliminary finding, which I think is to be expected, then we're going to have these conflicting orders. One saying the non-compete is perfectly well within the FTC's authority, and another holding that nope, it's invalid. So this split of opinions will probably both set up an appeals process that I think most people expect will likely lead to the United States Supreme Court, but that could take some time. If there is ultimately a nationwide ban, it would likely remain in effect during the appeals process. And of course, in addition to these things, we would expect that there will be other lawsuits that are filed until there's some final resolution of this. Certainly another thing that could come into play is if there is a change in administration in November, then we would have new members of the FTC, and this rule might change from the primary source as well. So a lot of uncertainty with all these. So as a result of all this uncertainty, what do you do now? What to do now? And we've talked about this in a couple of webinars, but one, certainly folks should be doing this already, particularly with the Labor Day weekend, as Brittany mentioned, coming right before the effective date. But continue to make sure that all individuals who are subject to existing non-competes are identified. This includes former employees that may still be subject, might still be within the restrictive term. So identify all of those, analyze any employees who would fall within the senior executive exception, and let them know that those agreements remain in force following the effective date. Those notices should be crafted. But I am certainly urging clients not to send those out until September 4th, or at least until August 30th, until we see what actually will happen. But those notices should be ready to go. And the notices should leave some wiggle room. This rule, even if it's not struck down in that August 30th ruling, it still could be, or it could be revoked. So, there should be some wiggle room in there that limits the scope of that notice that, hey, we're not going to be enforcing this to, the time that the final rule is valid. So if it later becomes invalid, you don't want the notice to be overbroad and prevent you from taking action then. Now is also the time to be reviewing, if you haven't already, your non-solicitation and confidentiality provisions, as we'll talk about in a moment. Those remain in effect. So you want to make sure that they are limited in scope so that they will remain permissible even if the rule goes into effect. And certainly as you're doing all these steps, make sure you're consulting with your counsel because these are some fairly complicated issues. So under the final rule, there are still restrictive agreements that are permissible, and we'll talk individually about those. But non-solicitation agreements still remain in force. You can still enter into those after the effective dates, as well as confidentiality agreements. You can also consider garden leave, which we'll talk about in a minute. You can have these agreements as long as those non-solicitation and confidentiality agreements are not de facto non-competes. So with regard to confidentiality agreements, and particularly with the additional scrutiny that they may well be subjected to, you want to make sure they're well crafted. Don't just say, hey, protect confidential information. Make sure you're defining what that confidential information is. That's not an exhaustive list, but you want to be identifying those kinds of things that employees should be treating with the most caution. Identify why that information is being disclosed to the employee so that a court later could see that you're not just willy-nilly handing out this confidential information, that there's a reason for its disclosure and that it should be protected. And certainly make sure the prohibition is with regard not only to use, but to dissemination, to copying, to theft, to disclosure to third parties, etc. So review those agreements, make sure that they are tight. Because the final rule does say that you can have these confidentiality agreements, but as we'll see in the next slide, it does limit them to say that it may be transformed into a non-compete if you're just seeking to prohibit employees from using information that arises from their general training, their knowledge, their skill that they gained on the job or otherwise, or that's readily ascertainable to other members or to the general public. So again, you have to be focusing on that information that truly is confidential to the company, proprietary, that you're sharing with them for a specific purpose, and that's not, just generally available out in the public realm. With regard to non-solicitation agreements, some things that you should be looking for in those agreements is making sure that you identify the importance of the relationship that the employee has with the customers or other employees to justify the existence of the non-solicitation provisions. Make sure you're considering appropriate restrictions on those non-solicitation agreements. So avoid overly broad prohibitions, such as you cannot solicit the company's customers. If the employee had no connection with some of the customers, had no knowledge of some of the customers, then that might be considered to be so overly broad that it's a non-compete under the rule. So you need to be careful about those restrictions. Consider necessary geographic restrictions. If you're talking about someone who has nationwide or global responsibilities, it's perfectly fine not to have geographic restrictions. But if you're talking about a salesperson who has a very defined territory, then it would likely, under a new landscape with the rule, it would likely be considered to be overly broad and perhaps a non-compete if that restriction does not track what the employee's actual responsibilities are. In terms of your agreements, non-solicitation and confidentiality provisions, and to the extent that they survive past September 4th, when you're reviewing these agreements, make sure you follow some best practices, like include an attorney's fee provision in there. And when you include that attorney's fees provision, make sure it doesn't just say that whoever prevails in an enforcement action is entitled to their attorney's fees. I see that too many times. It should be protecting the company, not be a blanket provision on attorney's fees. Include a notification provision in any of these agreements. And what I mean by that is insert a requirement that the employee has to inform subsequent employers during the restricted period that the employee is subject to these obligations and that the new employer, is notified of that. And also make sure that you include a provision that requires the employee to notify you of where they're going during that restrictive time frame. They may not comply with it, but it gives you a tool. Just backing up for 1 second. Our screens are still going crazy there. Make sure you have a tolling provision that extends the restrictive covenant in the event that there is a violation. So somebody might be out there violating a non-solicitation provision, might take you a while to learn of that, might be 6 months into a 18-month provision. You would want to include a provision that tags on that 6 months so you get the full benefit of the bargain there. Courts don't always enforce them, but they sometimes do, and it's also a bargaining chip to try to get an agreement hashed out with the employee or new employer. So another type of provision that survives and lives on even after the rule, if it indeed goes into effect, is something called garden leave. This is something that's used regularly in Europe, not so much here in the US, but it's an arrangement by which an employee remains employed per se, but does not have any responsibilities, basically goes home or goes to the beach for the period of the restricted, or for the restricted period, and receives their regular compensation. So you can cut off access to the workplace, take away the computer, no job duties associated with it. You're just paying them to sit on the sidelines, basically. And the final rule does not ban these leave arrangements because they're not considered to be non-compete clauses. This obviously would be costly to use with every single employee who was previously subject to a non-compete, but it is certainly something to consider with regard to key employees. It might be costly, but where that cost is outweighed by the risk that a key executive could pose by going to a direct competitor, it may be worth it. So certainly, again, something to discuss with your counsel as a means to further protect your interests. Another thing that survives, of course, the final rule is trade secret protections. And in fact, the FTC's rule specifically noted the continued use of the Defend Trade Secrets Act and the importance of trade secrets. Certainly, for those of us who practice in this world, we all recognize that non-solicitation agreements that survive won't provide adequate protections with regard to a lot of key employees. C-suite individuals are likely not having that face-to-face contact with customers and clients. Your developmental people, product people may not have contact with customers. So non-solicitation agreements won't go very far to protect your interest with those folks. So it's even more important that you really are focusing on trade secrets and how you can use trade secrets to protect the company's interests in the event that those kind of key employees who non-solicitations are useless for, in the event they go to a competing organization. So under the Defend Trade Secrets Act, there are some really critical tools for employers. First, it does provide for the recovery of punitive damages and attorney's fees if you have the applicable notice that the Act requires in your agreements. So you have to make sure that they understand if they're disclosing trade secrets in a whistleblower capacity, that's fine. But otherwise, you can seek the recovery of both fees and punitive damages. And the Defend Trade Secrets Act also allows for injunctive relief. And there have been many cases where we who do enforcement actions are able to prevent an employee from going to work for a competitor, even though that employee doesn't have a non-compete agreement, if there are trade secrets at issue. But the only time to prepare yourself and position yourself to be able to take an advantage of a strategy like that is before that individual leaves the organization. So let's talk about what some of those best practices are and what you can be doing now, even with the rule, to enhance those. First of all, make sure that there are protocols in place for the departure of key employees. So standard procedures that if folks of a certain position, a certain rank within the company, certain access to information, when those people leave, that there is a protocol that's followed. First of all, that is sitting down and reminding that employee of their obligations, and that's both contractual obligations as well as their common law obligations like the protection of your trade secrets. Provide notice to the new employer of what those obligations are of that employee. Hey, new company, we know so-and-so is coming to work for you there, but please be aware that they are bound by these non-solicitation and confidentiality provisions. Additionally, they were entrusted with a wide variety of trade secrets. We're going to be monitoring the situation, and we will hold you both responsible if any of those obligations are violated. So include that. Conduct an email review. Go on, have the IT department take a look at emails from the past 30, 60, 90 days and see if there's anything out of the ordinary. Still, it is common to find that the employee has emailed certain information to themselves, or that there's information in there, they've sent a resume to the new employer. Almost always there is at least a small nugget or two that you find in that email review once someone leaves. And certainly make sure that you have a practice when these key employees leave, that you are reviewing or at least preserving the hard drive of any computer or any device that they have used. When I say review, I don't mean have the IT department review the hard drive, because if someone reviews it before a forensic image is made of it, then that changes the underlying metadata, and it's going to be much harder to show that the employee may have been the one harvesting information in the final days before he or she departed the organization. If you don't think it's necessary to review the hard drive, at least preserve it. Preserve it for a year or two as best practices. You can put the device, put a new hard drive in and put the device back in circulation, but keep that hard drive. There are so many times when I have a client come to us and they have recirculated that laptop and have no way of tracking down if the employee has taken information. So if you preserve it, put it on a shelf, have a system in place that you have it, because the person may say to you, oh, I'm taking a new direction, I'm going back to school, I'm, don't know what I'm going to do, I'm going to retire. And then 3 months later, after the device is recirculated, you find out that that wasn't exactly the true story, and they are now down the street at your competitor. If the hard drive has already been cleaned and recirculated, you don't have a recourse. So have a system in place for doing that. Consider establishing monitoring policies. There's a variety of software that can be used to take a look at when key documents are accessed, or when a high number of documents are accessed, or just kind of routine monitoring, like routine drug screens. So that ability is in place and can help flag suspicious activity before employees are out the door. Make sure that your remote work policies are having considerations for the handling of trade secrets outside of your workplace, proper policies for how to destroy information remotely, where individuals should be conducting their work at if they're remote and not in the office, because you can destroy the integrity of trade secret information if that information is not handled properly, and that includes not being handled properly in the remote context. So the key again is to act now, because there's no way to change what you've done to protect your trade secrets once someone has already exited the company. So with that, that brings us to the end of our presentation, and we're happy to take some questions if anybody has them.
Yeah, so we have a lot of really good questions that have come in. So Debbie, I'm gonna give me a second here. Okay, so one question that came in was to clarify for the senior executive exemption, if it is both the compensation and the policy-making authority, or if that's an or. So do you want to speak to that a little bit?
Yes, I do. It is an and. So it's like some of the tests under the FLSA. First, they have to meet that salary threshold. If they don't meet that salary threshold, it doesn't matter what their authority is. On the flip side, they may meet that salary threshold. They may be, a senior VP of sales, and they're making a ton of money, but they're not making policy decisions that affect significant aspects of the organization. Likewise, they would not be considered to be a senior executive. So it is definitely both.
Okay. Next question, I can handle this one. So if an organization is claiming that the employee is in violation of a non-compete and they've already hired legal representation. So this issue's kind of already cropped up before September 4th. What happens after September 4th? So the final rule is clear that if the violation of a non-compete has accrued before the effective date, meaning that person's already in competition before the effective date and you have a non-compete with them, then you could still move to enforce that non-compete. This would really be for anything that would accrue, as to use their term, after the effective date. Let's see here. Another one we have, Debbie, can you talk a little bit about how employers should be handling hiring during this time, both before the effective date and maybe perhaps while we watch this appeals process play out a little bit?
Yes, certainly I would encourage employers before the effective date. I would use current agreements. I would use agreements that have the non-compete provision as well as non-solicit and non-disclosure, because it's much easier to issue a notice after September 4th if you need to on the non-compete provision than to try to get somebody to sign a non-compete if it's invalidated after they've signed one that, or signed an agreement that doesn't have a non-compete or doesn't have an agreement. It's harder to get someone, more difficult to get someone to sign that agreement after they're already employed. And depending upon which state the employee works in, it might not be, sufficient consideration. Continued employment might not be sufficient consideration, to support a non-compete that's entered into after they begin. So it might have to be tied to a bonus at the end of the year, or some one-time bonus, or an increase in compensation. It's just not as easy. So I would strongly encourage folks to consider continuing to use their agreements that are in place, or they're using prior to the rule, right up until that deadline. Afterwards, make sure you're still using non-solicitation and confidentiality agreements. And certainly if the rule becomes invalidated, then you go back to using non-competes and trying to put those in place with your key employees, recognizing the difficulties that you may have for those employees who are hired after September 4th.
Okay, great. So next one, I can kind of handle this just to reiterate and kind of piggyback off what you just said, Debbie. So we had a question about whether or not the final rule really includes confidentiality and non-solicitation clauses. So we've kind of discussed this, but just want to reiterate that now is the time. It's kind of already been the time, but it's certainly the time now to take a look at your confidentiality and non-solicitation provisions that are already in existing agreements that you're using, because especially after the effective date of the final rule, you really want to make sure that those clauses are not so overly restrictive that they could be deemed a de facto non-compete, in which case they would get swept in, and the FTC would say, this looks and talks and walks like a non-compete, so we're going to treat it as such. So it's really the time, like Debbie had talked about earlier, make sure geographic location, you're only restricting them from customers that they really have their hands on. And these are kind of the really nitty-gritty details that's really helpful to kind of talk through with your counsel. But again, you should have already been kind of doing this to better protect yourself for enforcing them anyways, but especially if you need to rely on these other provisions after the effective date of the final rule, certainly want to make sure that those confidentiality and non-solicitation provisions are revisited. Debbie, I guess this one probably for you. As far as the effective date coming up and sending out notices, what is the penalty that you're aware of if someone just doesn't send out the notice, but then just decides not to enforce a non-compete?
Yeah, that's a great question, and we have had a lot of questions about, well, okay, what can the FTC really do? And the way it looks is that the FTC could provide a notice, they could potentially commence an administrative proceeding or seek a district court injunction under the FTC Act. It doesn't appear that they could seek monetary relief for violations of the rule. Section 19 of the FTC Act allows the FTC to seek monetary relief for violations of consumer protection rules on unfair or deceptive practices, but it's silent on remedies for unfair methods of competition. And there's some authority that supports that it can't grant monetary relief such as disgorgement or so forth. So, you know, I have fielded a lot of questions from folks who say, well, what if we agree with the Texas court and we're not going to send these out? You know, it doesn't appear that there's a great many teeth other than a potential, you know, injunctive relief action by the FTC. But the real question would be enforcement. You know, would the court, would you be able to enforce with the rule? Are they going to follow Pennsylvania? Would they follow Texas? Would you be creating new precedent? You know, I think we're going to go into a lot of uncharted territory here, but yeah, that's the long and short on potential penalties there.
All right, we have several questions about conditional language, within the notices that people would send out. So, I mean, generally speaking, we would recommend including some type of conditional language in there. As far as the specifics of exactly what that should say, that's gonna, you know, be based upon what other agreements you have or you're utilizing. So that's really a time to reach out to counsel to kind of walk through what's the specific language in the notice you're sending out should look like, given your business, the other provisions that you regularly use and would be enforcing, and everything else you would want to kind of cover in that notice. So to give you verbatim language that should be included in there would be kind of an overgeneralization. So again, would really recommend kind of reaching out to counsel on those specific points. Let me see, we got time. Let's see if we got one more. All right, I think that sums up the high level questions that we had here, Debbie.
Great. Well, thanks, Brittany. If you do have questions that we weren't able to address today, please email or call your regular Thompson Hine lawyer. If you're not a current Thompson Hine client, please contact us and we can discuss available options to meet your needs. But thank you very much for joining us today and enjoy the rest of your day.